SJC-13639, BAC Realty, LLC et al. Versus City of Fitchburg Board of Appeals et al.
Okay, Attorney Powers, I see you're ready to go.
Good morning, Your Honors, and may it please the Court. Kevin Powers for the City of Fitchburg. With me today and with me on the brief is Attorney Vincent Pusateri. Your Honors, the cardinal points in navigating this difficult statutory language. First, the City of Fitchburg bent over backwards to accommodate this sober house as it has for numerous other sober houses. Second, the remedial purpose of paragraph 4 of section 3 is to prevent discrimination, not to thwart the legitimate purposes of local zoning in a congested city with limited parking. Third, the only way to read paragraph 4 without surplusage is to recognize what the appeals court recognized in crossing over 1, that paragraph 4 contains multiple comparators on the basis of a nuanced factual record and not a per se requirement.
Counsel, before you go launching into all of the roadmap stuff, do you agree, at least as I could read it, the judge's decision that Judge Kenton Walker erred where she added the whichever is favorable language to the comparators?
Whichever is most favorable to the sober house. Yes, Your Honor.
Okay, so when you have these different comparators, I know that BAK Realty is saying that you're supplementing an and for an or. Can you tell me again, which is the court supposed to look at both comparators or just one?
We believe, Your Honor, that the court should look to the most applicable comparator, but the phrase that are not imposed on families and groups of similar size is essentially a logic condition, and the test with the word and is of the words not imposed. In other words, if the zoning condition is imposed on families, then the condition not imposed on families and groups of similar size is not true. If the condition is imposed on groups of similar size, then the condition not imposed on families and groups of similar size is not true.
Okay.
And so perhaps the test could work either way, potentially.
So, I'm sorry, go ahead.
No, go ahead.
No, please.
Go ahead.
So I guess one of the questions, I know that you say that the issue in the appeals court case where they're saying we're not trying to turn this into a de facto situation where they'll never be treated as families. Are you saying that essentially that sober homes can never operate in single-family residential zoning districts?
Oh no, we're not saying that at all. What we're saying is that sober homes can operate in those districts. Number one, if they're able to operate as another form of permitted housing that's allowed within that same zone as another group of similar size. And we're also saying, as was true here, that in any event under the Fair Housing Act, they're always entitled to seek a reasonable accommodation. And in this case, that's how everything worked out, because the city of Fitchburg recognizes profoundly the importance of sober houses in aiding the recovering population and ensuring that as many resources are available to help folks as possible.
So that leads me to ask you, are you looking to have the decision of the ZBA affirmed?
Yes, Your Honor.
Okay.
And may I ask you one other question? I have a hard time understanding what relevance the 2020 ordinances have, given that the violation that's at the root of this case was issued in 2019, and therefore it could only be the 2018 ordinances that we should look at. Am I missing something there?
No, Your Honor. To be absolutely frank, I included those out of an abundance of caution because there's a footnote in the Superior Court decision indicating that the regs in effect at the time of the building commissioner and possibly the ZBA decision were not necessarily, at least in their entirety, in front of the court. And therefore, I thought it best, well, might as well include in the addendum both the regs that were in effect at that time and the regs that were in effect at the time of the Superior Court decision, just out of an abundance of
So
caution.
what are we supposed to do with the definition of boarding house in the 2018 ordinances? That seems, it may be inartfully drafted, but it seems to say a boarding house is only a group of people going up to six, between 3 and 6 people. So it wouldn't seem to apply to this situation, which has more than 6 people.
Correct, Your Honor. But that's where the Fair Housing Act mechanism for crossing over being able to seek a reasonable accommodation kicks in.
Okay, so I understand that piece, but does it mean, so I'm just trying, are you still pressing the argument that this was a boarding house under the 2018 regulations?
Yes, Your Honor.
How can that be when the number of people involved is greater than the number in the definition of a boarding house under your ordinances?
Correct, Your Honor. But essentially, this is, was it a boarding house by number? No, it was not according.
Boarding house by spirit?
It was, I would say it was a boarding house by use.
Okay.
And
Why do you need to go there? Because you told me you're looking to have the ZBA decision affirmed, and the ZBA decision deems this a 3-family. And so why are you going down the route of boarding house? Because, as I said, I don't want to repeat myself, but you want to have the ZBA decision affirmed, and the ZBA said this is a 3-family home.
my recollection, Your Honor, is that the ZBA agreed under the reasonable accommodation to treat this as if it were a 3-family.
Oh, I see.
Although it's not.
Can I get you back to some basics? You have a follow-up
that's
question?
fine.
So is this statute is there an error in the statutory language? The last "or" that are not imposed on families and groups of similar size, should that be of other related persons, or is that accurately written? Is there a plain error in this, just to start out?
Yes, Your Honor.
Okay, so, and that tracks the federal language, which uses of.
Correct, Your Honor.
So that's my first sort of basic question on this thing. My second basic question, okay, families, I have families who have 13 kids, one of my high school friends. So how does this work, that a family can be a big family, right? You can have 12 kids. So if this applies to families and groups of similar size, and a family has the right to be there, including a big family, I'm just not sure I understand this. How does this work?
Because here,
We've got 13 people living in a house. A family can have, again, I have a high school friend, there were 12 kids in the house. Does that mean you're discriminating against the sober house because a family can be large?
No, Your Honor. Family is defined in the zoning ordinance.
Right.
It can be larger if the family members are related by blood, marriage, or adoption. If the family members are not related by blood, marriage, or adoption, they can still qualify as a family if they are a single housekeeping unit, but they max out at a total of 4 members of the family.
All right. Now, one other sort of basic, what are we talking about here? We have sober homes. What other types of entities are we dealing with? Do we have a group of disabled veterans are in a house together? They're the same, right? They're like this, are they in the same category as what we're dealing with here, a sober home?
For purposes of a comparator?
Yeah.
Yes. Other possible comparators could be potentially a convent, a monastery, a parsonage with multiple priests living in it, a fraternity house. One could envision a variety of
A
scenarios.
house of homeless mentally ill people, if we create such a home, I'm just trying to get a sense of what the statute encompasses.
Oh, beg your pardon. I meant to refer to possible comparators that could arise in a zoning ordinance. As to what the statute is contemplating,
Any group of people gathered together with a handicap or disability are what we're talking about here, right?
well,
I'm just trying to, so the city we got disabled veterans living in a home. The city is not gonna allow that either, right? Is that's gonna violate this as well. I'm just trying to get a sense of what's encompassed here.
Your Honor, my understanding is that generally, and admittedly, the definitional section within 40A does not include a definition of congregate living arrangement, unfortunately. But my understanding is that generally, congregate living arrangements most often in Massachusetts arise as a cluster of units allocated by a local housing authority or by a contractor who has built affordable housing under contract with a local housing authority. This is a more unusual situation where it's being created, to the best of my knowledge, not in conjunction with a local housing authority or via contract therewith. But that being said, one could envision, if the definition applies to other circumstances, one could envision a variety of the scenarios that Your Honor described. Disabled veterans, individuals with, rather than in recovery, individuals with long-term disabilities or long-term
Attorney,
developmental conditions.
can I just ask you to go back to the beginning when you were giving that sort of logic thing where the if and or not? Can you do that again so that I can understand what the statute's saying?
Yes, Your Honor.
Okay.
The logic condition is that are not imposed on families and groups of similar size. And it's testing not imposed. The condition is not imposed on families and groups of similar size. Therefore, if a condition is imposed on families, then we answer the question, not imposed on families and groups of similar size, false. It is imposed on one of those. If the condition is imposed on groups of similar size, then we answer the test with, then we answer the test of not imposed on families and groups of similar size with false, because it is imposed on groups of similar size. Yeah. In order for the condition to be true, in other words, in order for there to be discrimination on the basis of disability, that condition must be not imposed on families and not imposed on groups of similar size.
That was what my initial question was, which you answered just now differently than before. So discrimination under the statute is a term of art, and that means that it has to be both comparators that you look to, not just the most appropriate comparator, right? So if you can impose it on families, then, and you can also impose it on and groups of other side, by definition, it's not discrimination.
Correct, Your Honor. Yes, the question is the condition imposed on either of these other groups?
Right.
And on either of these other groups, if they take the form of if they have disabled individuals within them, and so
It wouldn't be discrimination.
it wouldn't be discrimination,
Right.
on the
Okay.
basis of disability.
Okay.
Yes.
Can you just go back to something that Justice Wolahojian asked you? Under the 2018, okay, if they're not a single housekeeping unit, how many per floor under the 2018 regs were allowed? Is it the 6 max?
If they are not a single housekeeping unit, then we turn to boarding house, and under 2018, that would be at least 3, but not more than 6. So yes, Your Honor, that would be
okay,
the 6 max.
So under the 28 regs, they could have had a maximum of 18 in the spread across the three floors.
It's a triple deck, it's a 3-unit building, correct?
Yes, Your Honor, it is a triple decker. But as to Your Honor's point, Justice Georges,
Counsel's trying to phone a friend, if you want to.
beg your pardon. This zone, RB, Residential District B, does not permit boarding houses. And so therefore, and to go back to the test, Zone RB does not permit boarding houses with no disabled individuals, and Zoning District RB does not permit boarding houses with disabled individuals. The ban on boarding houses within that particular zoning district is applied strictly neutrally, without regard to the presence or the absence
So
of.
even though it would satisfy, this would be permissible if it were a family, because it's not permissible for a boarding house, you win, right? You're interpreting these clauses separately. It's not like you have to one way of interpreting the statute is, if you discriminate against families in this way, if you allow a family, if the condition is imposed on a family, not imposed on a family, I'm getting it backwards. If it's not imposed on a family, then it's okay, even if it's imposed on a boarding house? I'm trying to get a sense of, is it an and or an or when we're doing boarding houses and families? Is that clear? I'm not sure that was clear.
Maybe you should let him say it again.
Go ahead.
Because,
Try again.
and apply the condition that we're talking about in this case. Do you know what I mean?
Yes, Your Honor.
Okay.
Not imposed on families and groups of similar size. Here, the question is, we have here a group of more than 4 individuals per dwelling unit, and that is not permitted within this zoning district. It is
Boarding houses, but not families, or Do both. Do both the family analysis and the boarding house analysis for us.
Yes, Your Honor. The family comparator does not apply.
You know, you say it doesn't, but do apply the comparator for us, and then we understand the legal analysis. In this case, a family could do this, right?
A family could.
Because it's a single-family
It's a
zoning.
single housekeeping unit.
No, it's a triple decker, but a family can be in this triple
But
decker.
they're related people by adoption, blood, or something.
Or if they were unrelated, but in a single housekeeping unit of 4 or fewer. Here, we have neither. Number one, we don't have a single housekeeping unit. And number two, even if we had a single housekeeping unit at 5 per floor, we're in excess of the cap of 4 unrelated, and therefore, this is not a family under either definition in the Fitchburg zoning ordinance. Therefore, we move to the next comparator, which is boarding houses. This might have qualified numerically and by use as a boarding house. It doesn't qualify by zone.
By zone.
And
That's the 3 to 6. That's what the 3 to 6 number refers to, is the boarding?
Yes,
Okay.
yes, Your Honor.
Does the city take the position that the relevant dwelling unit to look at is each dwelling unit of the triple decker, so it's 3?
Yes, Your Honor.
Okay, so on the first floor, there was 3 people. Was that one okay?
I believe, Your Honor, that it was 5, 5, and 3.
Yeah,
It was.
so the 3 was okay.
The 3 was not okay, but I believe that was only because it was not a single housekeeping unit.
Yes.
Had it been a single housekeeping unit, that would have been okay because it would have qualified as a family of 4 or fewer unrelated individuals, maintaining a single housekeeping unit.
Can I ask a question? Sorry, Chief. Why does the logic require your result? That is, why can't one read this paragraph as saying that discrimination is a bylaw or regulation that is not imposed on families and also not imposed on groups of similar size? That is, it has to, if it's imposed on one but not the other, it's discrimination. But if it's imposed on both, then it's not. So that the treatment of this disabled person group is the most favorable of families and groups of unrelated people, similar size.
It did, because, Your Honor, if that were, then it would essentially override the proper purposes of local zoning, and it's our position that was not the intent of the legislature.
Okay, so you'll allow that this condition is ambiguous as to which one of the logic units apply, right? And then the reason you win is because the intent is really to treat groups of disabled persons the same as groups of similar size.
Well, Your Honor, I should mention there's one other profound problem with making the comparison in every single instance against families, and that is that family zoning is always the most preferential and the most accommodating.
Right, but the problem with that argument to me, and if you could explain this to me, that'd be great, is that the legislature did include families in this paragraph form. If they didn't mean that groups of disabled people would be treated akin to families, why wouldn't they have just said discrimination is regulations not imposed on groups of other unrelated people of similar size?
Certainly, Your Honor, because when a group of unrelated individuals qualify as a family, notwithstanding that they are unrelated, for example, in this zoning ordinance in this case, if we were talking about 4 unrelated disabled individuals who are maintaining a single housekeeping unit, they would qualify as a family, notwithstanding that they happen not to be related by blood marriage or adoption. And so therefore, the statute foreseeing those circumstances included the family comparator, because if we have a situation that does qualify as a family, then the local zoning ordinance had better not discriminate against this family, notwithstanding that they're unrelated, simply because they happen to have disabilities.
Chief, may I ask a question? Assume we were to agree with you with respect to count 1. What happens to count 3? Does that go back? Is that gone out of the case permanently now?
I believe, Your Honor, that all of the counts other than count 1 in this case have been resolved between the parties.
Okay, so we don't need to worry about that aspect of the judge's decision.
Correct, Your Honor.
Okay, thank you.
Okay, thank you.
With that in mind, Your Honor, on the basis of those arguments and the arguments articulated in our brief, we request that this court reverse the partial summary judgment on count 1 and order that judgment enter on count 1 for the city. Thank you, Your Honors.
Thank you. Okay, Attorney Tyne.
Good morning, Your Honors. Andrew Tyne for the appellees, BAK Realty and Crossing Over, Inc. First off, just to respond to Judge Kafter's point, which I think is, I agree with the appellants on this point, which is the word "or" in the statute, as the statute reads, not imposed on families and groups of similar size or other unrelated persons. I agree that I believe that should be "of." I believe that is a typo. If you look at page 26 of the appellant's brief, it's, he references the language from the House report regarding the Fair Housing Act and the reasons behind the Fair Housing Act, which I believe that House report's very important to the statute because the language, it mirrors it in many regards. And the "of" is contained within the House report and somehow didn't translate over to the statute.
Is there any other state that's adopted this similar type of language?
I haven't
from the
looked at that in a
federal
long
statute?
time. I believe maybe California, Seattle, Oregon is one of those.
Do they use or of?
I don't recall, Your Honor. I haven't looked at that in years.
So just Justice Wentland's question about creating the most favored status, meaning if you impose, again, I'm going to get this back, if you impose a condition that is not imposed on families and other groups of similar size, your view is it creates a most favored status. You have to meet both sides of that equation.
Correct. How I read this is that if a family can locate in a neighborhood, so can unrelated disabled individuals. And that's how the statute is written. Also, if on the other side of the "and" is if a boarding house could locate in a neighborhood, and that would allow 12 unrelated people. Then a sober house, a group home for unrelated disabled individuals, could locate in that neighborhood where the boarding house could locate.
But
So-
what does that do with the requirement of the single housekeeping unit? What does that do to that?
That's not built into the statute, and I think that's done purposely. It says that the cities and towns cannot use local laws, regulations, ordinances to create these definitions which exclude from their neighborhoods individuals in recovery, i.e. disabled individuals who choose to live together in a congregate living arrangement. So the cities and towns can't come up with their own definitions of family which say you have to be related. And therefore, under the statute, you can only live in this city or town as a congregate disabled, a disabled group of individuals. If you are a family, that would make no sense.
Well, it could make sense if the theory was that all of these folks are related by blood, marriage, or adoption, and there's a three-family house, and it's the Murphys, and it's several generations of the same family, versus three families with up to 15 people who are all individuals. They're not part of the same family unit, and essentially you've got 15 different lives being lived in in one home where we wanted single-family zoning. Why wouldn't that make sense?
It wouldn't make sense because if you go back to the House report, it says discrimination has been accomplished by such means as the enactment of or imposition of health, safety, and land use requirements on congruent living arrangements among non-related persons with disabilities.
Well, I know what you're saying, but I'm going back to the issue that not necessarily resolved, but the issue that the appeals court have. Because if you take the view that you have, the family is always going to be the comparator. It's always going to be the comparator, and if you can't do it to families, you can't do it for folks that aren't family either by blood, marriage, or adoption, or as a single housekeeping unit. You'll never be able to zone out boarding homes.
So families is not always the comparator. An example is Donahue versus the city of Methuen, which is one of my cases in federal court. That was a convent. And my clients took over that convent and used it for unrelated disabled people to live together. And the city challenged it and said that you couldn't use it this way. And the federal court agreed that because it was previously a convent with unrelated people living together in equal numbers, that was the comparator. And under the statute, that was a group of similar size of unrelated individuals who could live together, and said that was okay. So, and it's quite often where...
Okay, in a single-family residentially zoned area, families will always be the comparator.
Well, this wasn't a single-family neighborhood, but it was a convent.
Right,
so,
I'm saying, but this is a single-family this RB residential zoning is a single-family residential zoning.
yes, I'd like to agree with you, because I think the intent of the Fair Housing Act, which this statute is based off of, is to integrate disabled individuals into single-family neighborhoods. That is the whole intent behind the statute, is to give them access to housing where typically they weren't allowed, because they'd be pushed into neighborhoods that are boarding houses or near the train tracks or where other people don't want these individuals. And the focus here is specific to, the statute covers disabled individuals in general. It does cover disabled veterans. It covers other groups of disabled individuals and gives them the benefit of being able to choose as to what neighborhood they want to live in. But I know sober houses comes up over and over again, people in recovery from alcohol and substance abuse, and the reason being is because people have fear and prejudice against them. They're afraid that when they come into the neighborhood, they're going to harm their children and distribute drugs. So, most of the cases that I handle have to do with not blind people and not veterans, because everyone likes them, but people generally don't like people in recovery because they fear them. And, if you read the case law and if you look at the facts and circumstances of many of these sober houses, people that enter these types of houses, they're at the bottom and they're not there to hurt anyone else. That's already happened. They've already gone to jail, they've already lost everything, and they're practicing abstinence, they're being drug tested. And it's usually
So I
a way for them to
appreciate
come
all
up.
those policy reasons
Yes.
for allowing groups of disabled persons into single-family zoned places. Can you, though, address the statutory language and why your opposing counsel's reading of it, of the logic of the comparators, does not make sense?
Well, he wants to replace the word "and" with "or."
Well,
between-
no, because he's saying the bylaw shall not be imposed on families and groups of similar size, right? He's acknowledging the "and," so that if there's as I understand the logic, if there's a bylaw that is imposed on families, then it can be imposed on groups of disabled people. And if there's a bylaw that's imposed on groups of similar size, then it can be imposed on disabled people without it being discrimination.
And how I read that in his papers to mean that if that group of similar size is, say, a boarding house, and a boarding house is not allowed in a particular neighborhood, like it wasn't allowed in the neighborhood where this house was located, then the city could say, statute doesn't apply. Boarding houses aren't allowed, so your home for disabled individuals does not have to be allowed.
Right, that's the argument. My question is, why is that not a proper reading of the statute?
Because it goes against the whole intent of the Fair Housing Act, which the statute is based off of, which is to integrate people in recovery into single-family neighborhoods, particularly because those are perceived to be the best neighborhoods.
So you're basically saying that the statute requires that the density requirements of a local zoning code, it overrides the density requirements of a local zoning code.
Well, zoning really doesn't control density with respect to families. Zoning
Well, the number of people in a particular dwelling unit, that's a density requirement.
pretty much every definition of family in every city and town that I've looked in Massachusetts allows any number of family members to live together. So you can have 13 people. My mother's family had 11. They can move into a single-family neighborhood and live there. What really controls density are the safety regulations and the state building code, because the sanitary code, which I know it's not cited anywhere in the papers, is 105 CMR 410, is very important because it requires that each bedroom have 70 square feet for the first person and 50 square feet per after for each person in a bedroom. With respect to a whole house, they requires 150 square feet of habitable floor space per first occupant and 100 square feet for each additional occupant. So there's regulations in place which are not controlled by this statute, because this statute does not apply to state laws and regulations. So therefore, the sanitary code and the building code, with those limitations, require that a house of a certain size can only have a certain number of people. So density is controlled by those laws.
But if you go back to Justice Wendland's question, right, because I'm really interested in this, and you're saying it just outlaws it, but that's not what I heard your opposing counsel say. So why isn't his interpretation of the other comparator, why is that not consistent with the text of the statute, not the policy? Because if they're not family by blood, adoption, or marriage, and the definition of the family is the one that he talked about of the single housekeeping unit, and that limits each floor to 4. That's just telling you that if you can do it, but you can't do the number that you currently have.
Right. But that
So why isn't his interpretation consistent with the text of the statute and the and comparator?
Because the statute says that you can't, notwithstanding any general or special law to the contrary, safety laws, regulations, ordinances. So the town's ordinances, their definitions cannot be used to put a limit on the number of unrelated disabled people that can live together if a family could live in that same use. And the family under the statute is not defined.
But it goes back to my question then. So family's always going to be the comparator. It says family and another group of folks to compare it to.
But it isn't always the comparator because
In this case.
in this case, it's the comparator, yes. But in many other cases, it's not because
Why wouldn't the comparator be like 5 students who rent one of the units in this triple-decker?
I didn't understand that, Your Honor. So why would...
Why is the family the comparator in this case as opposed to groups of similar size? These are unrelated people.
Because families were allowed to live in this particular neighborhood in this three family, in
But
this
so
triple-decker.
are groups of unrelated people.
So for this sober home, this unrelated group of individuals...
Set aside the sober home. Aren't groups of unrelated people allowed to live together in each of these dwelling units?
with limitations, Your Honor.
With limitations. So why wouldn't those same limitations apply to this particular group of unrelated people?
Because that's the whole purpose of the statute, is to provide a
That they
preference.
be treated the same way?
No, to provide a preference to people in recovery so that they can have the same access to housing as traditional families and other large
No,
groups of unrelated.
I thought the purpose was to make sure that it's applied neutrally so that there is no discrimination. And I think the point was, there is no discrimination if this same group is being treated the same as these other groups.
Yes, Your Honor, but, so 5 unrelated disabled people, if you say they have to be treated the same as 5 people who aren't disabled,
And none of them can be in this zoning area
can be in many zoning areas.
Right.
And that's why I think the statute says if you have 5 unrelated disabled people, you have to treat them like a family. That way they can be everywhere.
No, I understand that's how you
And-
want it to be interpreted, but I don't understand how you get there based on the language of the statute, which I think
Right.
was,
Because if you apply it the way you're suggesting in this case, it seemingly runs, it butts up against our statutory construction where it renders certain parts of this statute superfluous. Because if you're going to say that family is the comparator and other groups of people are meaningless, it's meaningless.
It isn't, Your Honor. I didn't get to say it, but most, not many, not most, a lot of congregate living arrangements for disabled individuals move into former nursing homes, convents, and large buildings that aren't necessarily used for single-family housing.
And if we have that case in front of us, it's a different case. But this case is a single-family residential zoning district.
Correct. And the comparator in this case is the group of unrelated disabled people should be treated the same as a family that could live in each one of these units. But I have other cases
This is
where.
a pre-existing triple-decker.
Correct.
And
it's a
presumably
traditional-
your convent would be a pre-existing convent, hypothetical.
Yes.
So we're not talking about simply whether it's a this is, I don't know if this is a single-family district, is RB, which I assume is residential B. And if, I don't understand your hypothetical, because if the convent exists in a particular zoning area, it's pre-existing, then why wouldn't that just be the same situation here, which is you have a pre-existing triple-decker that we're going to treat as a triple-decker, and the convent would be treated as a convent?
Because for unrelated disabled people to move into a convent and be treated the same as the prior occupancy and use, the statute allows them to do that.
That would be a reasonable accommodation.
Well, to me, it would be just the language of the statute. A group of similar size of unrelated people,
Right, they
could
would not
live.
need to be deemed a family.
they would not need to be deemed a family, which is important, because if they were deemed a family, under the building code, they'd have to get a change in use and have to go through some other requirements. And I believe in the Donahue case, that the judge, that's one of the reasons he granted the preliminary injunction. The city was arguing that my client didn't get a new certificate of occupancy.
So follow that logic then. If they're then treated as folks that are not of family for each individual level of the triple-decker, and under the RB zoning district, the max per floor is 4, why, again, I get back to, if that's the comparator, these other groups, and this is how other groups would be treated, why can't the city say, you're over the number?
Because the comparator is a family in each unit, and a family does not have a limitation on the number of people.